Hello, dear students. Today we will be dealing with the introductory portion of forensic medicine and the initial portion of legal procedures and so when a doctor start practicing, there are many situations where a doctor has to face medical issues and which were document a doctor issues any medical certificate or sick certificate or illness certificate or fitness certificate or age certificate, whatever, or even a medical OP ticket or even a discharge certificate or a day sheet can be submitted to the court of law as an evidence by any of the persons, or the court itself can summon the hospital authorities to produce any of the documents from the hospital. So there are so many situations where a doctor will encounter medical legal issues or will be summoned to the court as a witness, the expert witness. So as a medical professional or as a doctor, should the person should have, you people should have the basic knowledge about the legal procedures, what are the do's and don'ts when you go to a court, and some basic knowledge about the legal terms and legal proceedings in our country. So, first we'll start with the introduction. So, first of all, let us see the definition of forensic medicine. Forensic medicine is the subject. It's the most important definition as far as a forensic medicine person is concerned. That means the application of medical knowledge in the administration of justice. When you, as a doctor, you will have a basic minimum knowledge about the medical subject, about the human body, how it works, and how the body functions, and what are things that can happen when a mechanical force is applied on the body, like that. So you are considered as an expert person to give an evidence regarding or give an opinion regarding the human body and its mode of reaction. So that is so your knowledge is applied for the benefit of the judiciary. That is forensic medicine. So that word forensic came from the word forum. Forum means in ancient days in the Rome and Greece, uh, the disputes were compromised or discussed and compromised, or the solutions were found in places where some respectable person from the community used to sit, and the people with the disputes or some other quarrel or some um, disputes come to that place. They used to discuss matter in that forum, and decisions were made. So from that word forum came the word forensics. And in some countries, instead of the term forensic medicine, legal medicine is used. Forensic pathology means study of violence on human body and unnatural death. So when a force is applied on the human body, what are the things that can happen to the human body, and what type of force will produce what type of injury, mode of causation, the mechanism that can those things are dealt with in forensic pathology. Uh, Example is the examination of the dead body and finding out the cause of the crime since the text. Then thanatology is a study of death and all its medical legal aspects. The death is defined there in that particular portion. Death is defined, how death is declared, and what are the methods of declaring death in a body, a person who is put on ventilator. Then what are the changes that take place under the human body after death? Like that. Clinical forensic medicine is the subject where examination of the living person is made for medical legal purposes. So when a living person is examined for giving treatment, that is purely a clinical subject. And when the body is examined, a living person is examined for medical legal purposes, then it is called a clinical forensic medicine. So, for example, examination of a person for age determination, if the birth certificate is not available, and if the person enters into some medical legal case, the age has got a very great value in that particular case or a crucial point, then the age of the person should be determined and there should be a valid document there. So, in such a situation, the person will be taken by the police to a medical officer and the medical legal examinations like physical examination, dental examination, and a radiological examination for the presence of classification centers and diffusion, all those things. So, that is one example of clinical forensic medicine age determination. Then persons with injuries may be brought for examination to find out whether to give your opinion, to get your opinion regarding the mode of causation of those injuries, the age of those injuries, examination of the scars, the original nature of that scar, the causation of that scar, etc. So these are the things that dealt with in clinical forensic medicine, and these are some of the subsections of forensic medicine, like forensic odontology, and all these subsections have not been well developed in India, in Western countries. They are all separate specialties. Forensic odontology is examination of teeth and inferring certain medical legal matters like age of the person, the race of the person, some other matters like causing injury to that, what is the mode of causation of injury to that, to the age of injury of to etc. Forensic serology deals with examination of the blood stains or salivary stains, seminal stains, etc. Forensic entomology deals with examination of insects to get some information regarding the time of death of that person, the dead body. Some insects may be there. By examining the insect's body, some idea about the time of death of that person would be obtained. That is forensic entomology. Then forensic osteology is examination of the bones for getting certain medical legal points. Like a set of bones or a single bone is obtained from a particular place and the identity of that bone is not available, a person having medical knowledge can examine that bone and can first find out whether it is human bone or not. Then if the gender of the bone is a male bone or a female bone, then age can be determined up to some extent. If it is a long bone, the length of the long bone can be taken and it can be applied to a regression formula which is already available and the approximate stage of the person can be determined. Then comes forensic anthropology where the body measurements are described and the ratio or the proportion of different body parts, etc. Then forensic radiology is the examination of X-ray or radiographic examination for determining the age of the person or some other matters like some diseases or fractures like that. Then forensic ballistics is the examination of the firearms and the medical legal aspects related to that. Forensic psychiatry is the mentally ill person's medical legal responsibilities, civil responsibilities, criminal responsibilities of a mentally ill person, and the legal aspects of while dealing with a mentally ill person like that. And forensic nursing means the medical legal duties and responsibilities of a nursing staff while dealing with a medical legal case. Toxicology is one subsection which is um, uh, constitute about 1/3 or one-fourth of the whole of forensic medicine, and orphala is the person who's written down or who's found out different toxins, different poisons, the signs and symptoms, etc. So he's known as the father of toxicology. He was a chemist by profession. And in toxicology, the different poisons are described, their fatal dose, fatal period, the signs and symptoms produced by them, the treatment aspects and the medical legal aspects are dealt with. Then comes the second definition, that is medical jurisprudence. Medical jurisprudence means juris means law and prudentia means knowledge. The legal aspects of medical practice. Here, when you practice a particular profession, you should be aware of different laws related to that profession. Like what are the do's and don'ts, and what are the laws related to that. What is medical negligence? What are the things that constitute medical negligence? What are the defense points that can be put forward when there is a suit against that doctor for medical negligence? What are the duties? What are the responsibilities of a doctor? What are the rights of a doctor, etc. So those are known as medical jurisprudence. Then comes medical ethics. Ethics. The word ethics came from the word ethikos, means rules of conduct. They are the moral principles that should guide the medical professional in their dealings with the patients and the state. So there are code of conduct laid down by the Medical Council of India. Now the Board of Governors. Medical Council of India has been abolished and has been taken over by the Board of Governors. And that is the code of conduct. There is a code of conduct. What are the things a doctor should do and should not do? And so this is known as medical ethics. And there are certain basic principles of medical ethics. We will be dealing with that later. Medical etiquette as the conventional laws of courtesy observed between the members of medical profession. When you deal with your fellow doctor, your peers, what are the things that should be done, or what are the things that should not be done when you deal with the and a basic principle is that you should never make a degrading comment against your fellow doctor to a patient. After reading the prescription, you should not make adversarial comments regarding that prescription to the patient. If you have any difference of opinion, you can express that in another forum, not to the patient. For a doctor, when you, since we are dealing with forensic medicine, the subject forensic medicine, not about clinical doctors, for a doctor who is a clinical doctor dealing with medical legal duties, medical legal duty, he should have an impartial stand. So you have no accused to be punished or no victim to be saved. You don't think that he's an accused person and he should be punished. That is not the role of the doctor. It is the duty of the investigating officer to find evidences and to present it before the court, and it is the duty of the judiciary to find out the evidences should be weighed by the judiciary, and it is the duty of the judiciary to find to come to a conclusion whether the person committed that crime or is there any evidence of committing that crime and whether the person should be punished or not. It is not at all the duty of the doctor. So the doctor should present the facts before the court, and whatever opinions you give should be based on scientific knowledge only. No, if there is never give dogmatic opinions which cannot be explained as per your scientific knowledge. So only scientific facts and explainable scientific facts alone should be expressed in a court of law. Coming to Indian Penal Code or IPC, it came into existence in 1860. That is the one which describes offences and punishments. So here, multiple offences are defined. What constitutes that particular offence? What constitutes murder? What constitutes kidnapping? What constitutes abduction, like that? And there is a particular number, section number also, and punishments are also described in the coming or the subsequent sections. Criminal Procedure Code, from here in after it should be mentioned as CRPC, Criminal CRP Procedure Code, CRPC. So it came into existence in 1860 and amended in 1973. And here the legal procedures in various criminal matters are dealt with. So, what are the things to be done while investigating a case of or a criminal case? All these things are mentioned in the procedure code. Then comes Indian Evidence Act 1872. Laws of evidence in various judicial proceedings are dealt with. That means how to collect the evidence from the scene of occurrence or from any other place. How to make, how to uh, hand over the evidence from one person to the other, and till it reaches the court of law as evidence. What are the procedures to be followed? All these things are very um, described in a detailed manner in Indian Evidence Act. Then comes civil case and criminal case. Civil case means dispute between two persons or two parties. Example, land dispute, a property dispute, or divorce. So here husband and wife are involved. Property dispute, two persons A and B may be involved, or a party A, a group of people, and another party may be involved. Anyway, it is between two group of people or two persons. There is a dispute between them, and that can be presented to a civil court, filed in a civil court, and both parties can engage their own lawyers, and they will have the argument there, and a decision will be made by the civil court judge or magistrate, and that has to be observed by the parties. An appeal can also be given to the higher court. Then comes criminal case. Criminal case means, or before that, what is a crime? Crime is an, an act or an omission to do a particular act which is prevented by defining punishments or by giving punishments by the state. So, certain things are defined as offences and punishments are prescribed for such offences by the state in IPC. So, those things are known as crimes. So, a crime can be an act which is punishable or an omission to do a particular act which is punishable. If you don't do that act, that is punishable. That is also a crime. So, those things, those acts or omission of that act which are considered as punishable in a country are called crimes. So, a criminal case, if occurs, that will be taken care of the victim or the sufferer of that particular incident would be represented by the public prosecutor or the assistant public prosecutor in the court of law, and the person or accused person will be represented, or he can engage a defense lawyer there. So the burden of proving that case lies with the public prosecutor, or the victim's side should prove that particular case by producing ample evidences before the court of law. The duty of the accused person, his lawyer, is to defend that particular case. So that is criminal. And cognizable and non-cognizable offences. Cognizable offences are the offences where a police can arrest the accused person without warrant. Those offences are described in first schedule of Criminal Procedure Code, and here the punishment is with more than 2 years imprisonment, life imprisonment, or death sentence. Example, rape, murder, etc. That is the offences of higher gravity. Non-cognizable offences where a person a police officer cannot arrest a person without warrant. Punishment is with less than 2 years. Example, hitting with a hand without a weapon. When one person is hitting another person, considered as a lesser form of crime called non-cognizable offense. Bailable offense means where bail can be granted and non-bailable bail cannot be granted. Warrant case means cases of cognizable offenses. 2 years imprisonment and more, life imprisonment, or death sentence. Such offences are known as civil warrant cases in the court of law. Summons case means of non-cognizable offences. Then lesser gravity offences are represented as summons cases before the court of law. Now coming to the important portion, inquest. Inquest means an inquiry into the cause of death, or a preliminary inquiry into the cause of death. When a death occurs, or there are only two types of death in possible: natural death and unnatural death. Natural death means the pure natural death, or it means a death occurring due, during the aging process, or as a natural process uh, 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 proceeds and terminates in death of the person. That is, all the physiological mechanisms comes to stand still, and that's called a natural death. It can happen due to other natural diseases also in between. That is pure natural death. And second group is unnatural death. So unnatural death can occur in three different manners. One is accidents, suicides, and homicides. These are the only three manners of unnatural death. So total four manners are there. One is natural, second group unnatural. They are again divided into three: suicide, accident, and homicide. So whenever a unnatural death occurs or a suspicious death occurs, suspicious in the sense of a person found dead, nobody is sure whether it is a natural death or an unnatural death, whether this person is having some natural illness or not. So later on, it may suspicion may arise, and so such cases should be reported to the investigating officers. So the investigating officer in our country, police officers are the commonest investigating officers, or in almost all the cases. The case will be reported to the nearest police station. Police will come, should be inquired by a police officer not below the rank of sub inspector of police. The person will inform the executive magistrate regarding the occurrence of that death, and he'll proceed to the scene of occurrence, and he'll summon certain people, some respectable person from the society, 2 or 3 persons, and other neighbors and nearest relatives who are available will be asked to give their opinions regarding that particular death and history, the previous activities. Everything will be taken. History of all those things would be taken, and the police officer will write down all those things, and a beautiful record of all these things will be made. That is called inquest. It's a detailed report of that is led to death of that person. So at the end of inquiry, if the police is convinced that there is nothing to be suspicious about that particular death, he can release the body to the relative. Suppose the person was under treatment for a long time for cardiac failure, but the person was found dead on the roadside, and it can lead on to suspicion later on. But the police investigation, the relatives can use all those records and can give some certain informations uh, uh, which can substantiate the sudden death of the person, and the police, if convinced, he can release the body to the relatives. Otherwise, if he is not convinced, or if he has got some suspicion regarding the death of that person, then he can send the body for postmortem examination. So the persons who are giving their opinions, or the people who are signing, that is called panchas, and the record made at the end is called inquest or panchnama, and that record will be there, and from that the brief description or the brief history will be recorded in a form called KPF 102, Kerala Police Force 102. There is a printed form there regarding the preliminary details about that particular person, and a brief history as to the cause of death and a brief history prior to the death. All those things will be written, and that will be given to the nearest medical center where postmortem examination is conducted. Since ours is a private medical college, here postmortem examinations are not allowed. There is no government order for doing that. So, in a government institution, the form will be given and postmortem examination will be conducted. So that is called a police inquest. And the second type of inquest is magistrates inquest in our place in India. So these are the two types of inquest prevalent in India: police inquest, which is the commonest type, and then comes magistrates inquest. And where police is a culprit, or the police force is in the accused side, then not on the accused side, the police is in the are considered as culprits in certain situations. So what are the situations? One, death of a person in police custody, police firing or police interrogation, or a man missing from police custody, or rape happening in police custody. In all these situations, police cannot conduct an inquest, and magistrate should conduct. Mandatorily, magistrate should be the person who is conducting that inquest. In addition to these situations, death of a mentally ill prisoner in a psychiatric hospital, death of a person in a prison, exhumation, that is digging out of the already buried body. So for primary postmortem examination, police can conduct inquest. But once the body is buried, to take out that body later on, if someday raises some suspicion, has to be, and they say that further investigation need to be done on that body. To take out an already buried body, magistrate should be present at that site, and that person should conduct inquest. So exhumation is another situation, and dowry. A death of a married woman within 7 years of marriage in husband's house, and there is a history. There are suspicion, or there are uh, allegations against the husband or his relatives for harassing this particular woman for want of dowry. In such situations, it's called dowry death, section 304B. So in that situation also, magistrate should conduct inquest. So police inquest, it's called, it is dealt with under section 174 of Criminal Procedure Code, magistrates inquest 176 of Criminal Procedure Code, and these are the officers who are considered as magistrates for conducting inquest: executive magistrates, collector, deputy collector, RDO, revenue divisional officer, subdivisional magistrate or SDM, tahsildar, deputy tahsildar. So these are the persons officiating as executive magistrates, and these are the situations where a magistrate should mandatorily conduct inquest. It is very important. The third type is coroner's inquest. Coroner is a legal person. This has office is called court of inquiry, and the judicial has got judicial powers, and he can summon a person to his office, and he can make open verdict. And it is prevalent in USA and UK, and it is has been abolished in India in 1999. Next comes medical examiner system. Here, a medical personnel or having medical qualification is the person who is conducting inquest. That person can proceed to the scene of occurrence, can examine the body in the scene itself, can find out certain evidences or can collect evidences from that scene, and can examine the body in the scene itself, the changes there, anything, any blood stains, anything, everything can be examined by that person, and the body can be transferred to his own office, and he can conduct a postmortem examination also. So this doctor or forensic pathologist has got ample opportunities to find out all the evidences in the scene of from this can collect evidences from the scene of crime and from the body in the postmortem room, autopsy room. So this person is having a whole picture about that particular case, and this type of inquiry is considered to be the superior most type of inquiry, and it is prevalent in many states of United States of America and never occurred in India. Then comes procurator fiscal system. It is prevalent in Scotland, and the procurator fiscal is an officer who used to deal with the financial matters. Fiscal means financial, and collecting dues and fines during the period of uh, uh, the crown, and that officer may be a person having some legal qualifications or a lay person having some experience. So it is prevalent in Scotland. So we have dealt with 5 types of inquiry. Definition of inquest is very important. Different types of inquest very important. Differences between police and magistrate inquest very important. The officers who are considered as executive magistrates, the situations where a magistrate's inquest is necessary, all these things are very important. So the 2 types of inquest prevalent in India are um, police inquest and magistrate's inquest. The other 3 are coroner's inquest, medical examiner system, and procurator fiscal system. The second part of legal procedures and courts, that is the how the court proceedings are conducted, how who is a witness, what is an evidence, what are summons, all those things would be dealt with in the next part.